Hi, good morning, council's interested parties. We are back on the record in the matter of the state of Georgia versus Cleef Adams et al. In 22 SC 183572. Let's see, Mr. Stillwell, Mr. Sharp, good morning. All right, Mr. Williams, Mr. Steele, Mr. Adams, and okay, good morning. All right, Mr. Kendrick and Mr. Weinstein, good morning. All right, Mr. Ewing, Mr. Matthews, Senior, good morning. All right, Mr. Nichols, Ms. Westmoreland, and tis you. Okay, all right, good morning, madam. And Mr. Ryan and Misty Williams, good morning. All right, Mr. Housekeeping, Mr. Atkins, and Ms. Love, good morning. Good morning. All right. Okay, the first thing I wanted to take up, councils, is Mr. Williams' motion to motion to supplement the motion limiting number 2, motion to strike in regards to the court's earlier rulings consistent with the lyrics and songs that I said that the court will preliminarily admit subject to a foundation. Since that ruling, there has been a case by the name of Baker, and it is case number S23 Alpha 0860, decided 5 March of 2024, concerning issues that may bear upon the court's ruling. Mr. Steele and who's ever arguing for the state, I'm willing to give you 30 minutes apiece, because I've read Baker, and of course I've already made a ruling, so it doesn't really require me to get spun up or educated that much on it. So consistent with that, I'll start out, Mr. Steele, since it's your motion, go right ahead. You may.
Now it is. Thank you. Okay, Your Honor, thank you so much, and good morning, Honorable Court. Good morning to everyone. I did file what the court has already announced, and I appreciate the court's time to consider the Baker case. In the Baker case, Your Honor, I know you've read it, heard what you just said. I focus then on the fact that Baker was not a gang case, not a RICO case, not a conspiracy case, a RICO conspiracy case. I understand that, but it did involve the playing of just a video, what was deemed by the Supreme Court of Georgia, a rap video, no lyrics, because the lyrics were not understandable. But the reason that I found it important to raise on behalf of Mr. Williams, our supplement to the motion, in limine number 2 motion to strike, filed on the 6th day of March 2024, the day after Baker was decided, was that the highest court, and it's a 7-2 opinion in Baker, really took to task the use of a video, just the images. The video was, and I'm quoting from Baker, the video was glorifying violence and gun violence and a sort of street life, glamorizing it. And then I go to footnote 16, and I've given the Honorable District Attorney already a copy, and I've given this Honorable Court and the Honorable Mr. Kearns a copy of the 3 cases that are in footnote 16, where the Supreme Court of Georgia wrote, we note that the probative value of the rap music video was further diminished by the state's failure to present any evidence that Baker's performance of Crawford's rap song was not wholly theatric. And then they cite the United States versus Gamory, Gamory, which I'll get to, Your Honor, and they write, explaining that a rap music, they being the Supreme Court of Georgia, explained that a rap video was minimally probative under Federal Rule 403 because there was no proof that the appellant authored the lyrics or that the views and values reflected in the video were in fact adopted or shared by the appellant. So I thought that was important because here the state is trying to introduce numerous lyrics and videos.
Let's talk about that. Baker arguably involves the introduction of a video which there's little nexus to what they're trying to prove. Could you discuss for me how that, in this particular case, the state has said, look, we're gonna tie this to some aspect of membership, of leadership, and other things that are required to be proven under the gang statute. So tell me how, if you could distinguish that for me or talk about that, because I think the facts in Baker are a little bit different than the facts in this particular case. And remember, I've also told you it's subject to foundation. So, so address that for me if you wouldn't mind.
Sure. So I don't believe that the state will show any type of nexus. And in New Jersey versus Skinner, SKINNER, which is 95A as in Atlantic 3D 236, 2014, cited, the reason I'm using it is cited in that footnote 16, and in the copy of the copy that I gave this honorable court, the printed copy this morning, and the parties in page 11 of 15.
Are you talking about Skinner?
Yes, it should be on top, Your Honor. New Jersey or versus Skinner. And on page 11 of 15, it's footnote 5, which is at the bottom right. And I think that answers for me the question, and that was cited by our highest court in Baker. And it specifically says in that footnote, of course, rap lyric evidence that provides direct proof against a defendant, such as an admission or details that are not generally known and dovetail with the facts of the case, should be analyzed for relevance under 401 and evaluated under 403 standard for prejudice, and not the standard for prejudice under a Cofield analysis. And then they cite another case from New Jersey, recognizing intrinsic nature of evidence that directly proves charged offenses as excluded from 404B's analytic framework. A jury need not be shielded from a defendant's confession simply because it conveyed in a rap or other artistic setting. And what I'm saying here is, Your Honor, the state can't do that. When we had that last hearing, it went till late at night. the state was saying things like, and I'm just using out of the indictment, I ain't killed nobody, but I had something to do with that body. They just said, there it is, Judge. That's what we're saying. We're saying that Mr. Williams' hands are always clean and he has other people kill for him because he's the leader. That lyric, first of all, is used in other songs, which I've mentioned to court previously. But in addition to that, that's not something that's unknown. There's no details. There's no nexus. This honorable court, to admit that, is just admitting the artistic work, doesn't know if it points to any type of killing. It just goes to propensity. And I believe under Baker, 403 analysis should shield it. So I hope that answers your question, but that's what Skinner says to me from New Jersey. That was cited by our highest court. In Commonwealth of Massachusetts versus Gray, which is another case I've given this honorable court and the parties, and it's on page 12. Oh, I'm sorry, it's 978 New England or New Northeast 2D, NE 2D 543 2012. On the opinion that I've given to this honorable court and the parties on page 12.
Of 13?
Yeah.
Okay.
On the left-hand side, the first full paragraph, it's in the center of 12. The video, I'm just reading what the court wrote from New Jersey. The video was produced at an unknown point in or before 2005 and was available on a commercial website promoting rap artists. The defendant did not write or perform the lyrics or produce the video, and it was not found in his possession. The lyrics show no connection to the defendant that would suggest that they were, biographical or otherwise indicative of his own motive or intent at the time of the shooting. Yet the video was admitted specifically as an asserted statement of gang allegiance by the defendant based on Sheehan's, which is SHEEHAN, possibly as voir dire testimony to its meaning. Even if the video had contained direct statements of the defendant's gang allegiance, we are not persuaded by the opinions of courts in other jurisdictions that view rap music lyrics not as art, but as ordinary speech, and have allowed their admission in evidence as literal statements of fact or intent without contextual information vital to a complete understanding of the evidence. And to answer your question, I hope I'm answering, but the state can't do that. They didn't proffer to you anything that would associate these lyrics with a certain crime. The closest they came is they told the court that trestle tree, that Jeffrey Williams said the word trestle tree, which is a section, a street where crimes were committed in this case. The fact that he is using trestle tree in a song certainly cannot be that he's somehow involved in that crime. In addition to that, the prosecution has spent 4 months showing or trying to show that Mr. Williams is the leader of this gang. They have put on over objection Mr. Bean's recorded statement with Detective Quinn saying that Jeffrey Williams orders, he commands Mr. Murphy to do something. They put on Trontavious Stevens, who said inconsistently, but said Jeffrey Williams is a member of the gang. They put on that Jeffrey Williams is the slime, the big slime, King Slime, rather, excuse me. They put on Detective Belknap. They are going to use, over objection, Detective Gaither as a gang expert on YSL. They're going to use Detective Dennis as a gang expert on YSL. Over objection, they're going to use Investigator Viverito as a gang expert on YSL. And all of them make, for certain, over objection, Mr. Williams the head of this supposed criminal organization. So why did the lyrics have any probative value if it's simply cumulative? I'm trying to answer your question, but my point is to use the art, to assume that that is statements that the state argued are confessions. That's what they said. These are confessions. They said that we didn't go out and find them. Mr. Williams, handed them to us. These are his inner workings of his mind. But it's an artistic industry that our courts now, for the first time, this is the first time in Georgia, our court has said in footnote 16, we got to be careful. And they cite to these cases that say you got to be careful. The next case cited by our highest court is United States versus Gamory, Gamory, and that's 635 F 3rd 480. It's 11th Circuit 2011. Again, it's in footnote 16 of the Baker case. And on the copy of the opinion I give in this honorable court and the parties, it's in Division B, as in Barry or Bravo, and that starts on page 7 of 11, Your Honor. And it's entitled The Rap Video. These are lyrics and video, just like the Gray case and just like the Skinner case, were lyrics and video. And I am targeting on page 7, the right-hand side in the center paragraph that starts with the following. Based upon our independent review, I'm sorry.
I'm waiting on call.
Yeah, no problem.
5 minutes back in, okay?
Whatever you say. Yes,
All
sir.
right, go right ahead, sir.
In United States versus Gamory, and it's on page 7 of 11, Your Honor, on the right-hand side under the rap video. Starting in the center, the 11th Circuit wrote, based upon our independent review of the rap video and the totality of the record, we conclude that it was error under 403, Federal Rule of Evidence 403, to play this rap video to the jury. We recognize that the video could be construed to discuss Gamory in as much as the lyrics refer to JB, a white crib, a Range Rover, drugs, and hush money. And because the artist in the video, Tone Flora, F-L-O-W-A, wore a necklace with a JB insignia and was similar to cufflinks seized during the search of Gamory's residence. But the substance of that video was heavily prejudicial. The lyrics presented substantial danger of unfair prejudice because they contained violence, profanity, sex, promiscuity, misogyny, and could reasonably be understood as promoting a violent and unlawful lifestyle. At the same time, the video was not clearly probative of Gamory's guilt. We cannot ignore the simple fact that Gamory was not in the video. Neither was there any evidence that Gamory authored the lyrics or that the views and values reflected in the video were, in fact, adopted or shared by Gamory. We are also mindful of the fact that the government introduced the rap video at the end of its case after it had already presented significant evidence that Gamory was JB and he owned Hush Money Entertainment. These facts are not seriously contested at the time the video was introduced, and such evidence was therefore cumulative. In short, the probative value of the rap video was minimal at best. More importantly, substantially outweighed by the video's unfair prejudice. We have already said that Mr. Williams owns YSL. He is an entertainer. He goes by the performer's name, Young Thug. He associates with people that are unfortunately indicted. Some of them pled guilty, like Mr. Kendrick. They have done music together. Mr. Arnold, they've done music together. He pled. Mr. Kitchens, they've done music together. He has pled. It just doesn't need, and they don't have that connection. And again, going back to footnote 16 of Baker, Your Honor, the court wrote when discussing State versus Skinner, the difficulty in identifying probative value in fictional or other forms of artistic self-expressive endeavors is that one cannot presume that simply because the author has chosen to write about certain topics, he or she acted in accordance with those views. And all I believe is going to happen is you play those videos with those lyrics, or you have somebody say, here are the lyrics taken out of context, then the jurors will be horrified and be prejudiced, as was in Baker. That is pretty much my argument. I am not changing anything I relied on. I heard what the Honorable Court said, and I did understand you to say that the state has to lay a proper foundation before they can admit any of these, but that foundation now, according to Baker, is really tied hard to specific facts and not just generalities. That's my argument.
Okay, all right. Thank you, sir.
Thank you, Your Honor.
All right. Mr. Shard, I'll give you the opportunity to make your argument now, or you can wait till I finish with, because you've got some similar probably argument, so.
I didn't hear the last.
I said you got some similar argument, that's what I was.
I heard you say I can make it now.
Yeah.
Okay.
Yeah.
Would you like me to make it now?
Yes.
Okay. No, Your Honor, just for clarification, I filed motions regarding two different pieces of
Yeah,
potential.
you have a motion to,
One is a song.
yeah, one is similar to what Mr. Steele filed in terms of Baker. And then the other one was a motion limiting to strike regarding song lyrics.
Right.
Is that
I mean, both Baker touches upon both.
Okay.
In Your Honor, what I'd like to do is, just so we're all clear, these last less than a minute. If I could just publish them to Your Honor so we can see exactly what we're talking about. Mr. Weinstein, if you'd help me out. Either one is fine first. Yes, sound.
I've unmuted it. Hey, Mr. Kokomo. Do you know how I get sound?
Gotta cut your sound off.
I ain't serving no pack, I'm trying to rob him. And I keep a stick, ain't no avoiding no smoke. Drop top, cool. Top. Looking for who? Let it bang when you free. That's safe for you. Get you flipped in the scene, I'm on Rodeo. I'm that slam they always talk about. Hash that never touched them now. I just beat a murderer. Pay my lawyer 30 for that. Pay my slams a butter law. Ain't walking no quitter. She like, we in the door, yeah, young nigga, wait, shake these bodies off. Then I wipe your nose, sit in your femme, baby, and just slide it off.
That same shit that got Big and Tupac killed.
All right, so, Your Honor, that was the song.
Can we mark it as an exhibit for purposes of the motion?
We can.
Mark it as Stillwell 1 for the purposes of motion.
Okay, Stillwell 1. Okay, and that will be the verse from the song that in my motion, I titled Smile It Off.
Smile it out?
Yes.
Okay.
And then this is a social media post that was provided in discovery.
All right.
Yes.
And this is the second one?
Yes.
That same shit that got Big and Tupac killed, little fuck, nigga. Pussy ass nigga, get your bitch ass killed. YSL for life. Yeah. Hey, gang, you bring your pussy ass down here, you gonna see me. I'm at your fucking neck. Fuck anybody.
Was that it?
So that's Stillwell 2?
I don't think that was the entirety.
I'll just play it again.
That same shit that got Big and Tupac killed, little fuck, nigga. Pussy ass nigga, get your bitch ass killed. For life. Yeah. Hey, gang, you bring your pussy ass down here, you gonna see me. I'm at your fucking neck. Fuck anybody.
All right.
So that's Stillwell 2?
That is Stillwell 2.
Okay. All right. What's that called? Is that just a social media post?
It was social media post on Baller Report. I believe we could call it.
What date?
It doesn't, to my knowledge, it doesn't have an exact date.
On or about?
In the discovery, I don't believe it had a
On
date.
or about date?
I don't. I mean, I could speculate, but just by how old my client looks, but I believe it's probably from 2015, but I don't know that for an absolute fact.
All right. So it's a social media post?
It is.
Okay. All right. So I'll consider Stillwell's 1 and 2 for purpose of motion.
Okay. Thank you, Your Honor. All right. So obviously, I'm objecting to the admission of both of these videos, and I think the analysis is similar for both. First, I think we need to ask what the state's theory of admission is. And the first question that you asked Attorney Steele about his issue, I think is important to ask in this case. What is the direct nexus? What nexus is there to any allegations in this indictment, in crimes? Regarding the video Smile It Off, I will concede it is listed as an overt act, 95, okay? and I'll get back to that. My stance is just because the state pleads something as an overt act doesn't make it automatically admissible. If I had a client who said something in a confession that was deemed inadmissible for Miranda violations by the court, and the state decided to put it in their indictment as an overt act, it wouldn't overrule the gatekeeping function of the court to keep it out. So, so that is listed as an overt act, but it has no ties and no nexus to any substantive offenses. Essentially, in that rap video or in that verse, I believe that you can see my client. Now, I know the state has pointed out in previous pleadings, he is allegedly wearing a YSL necklace and he's allegedly wearing red. What does he says, he talks about going to, I believe he says the plug, but essentially robbing drug dealers, drug distributors. He boasts of keeping a stick, which common parlance is an assault rifle, on him. And he says, I just beat a murder rap, paid my lawyer $30 for that. Now, none of those statements, robbing drug distributors, that has no direct nexus to any substantive charges in this case. Keeping a stick has no direct reference to any charges in this case. I just beat a murder rap, paid my lawyer $30 for that. Now, I think it's fair to say that that is most likely a reference to being wrongfully arrested back in 2015 for the murder of Donovan Thomas. He was arrested in October 2015. He stayed in jail for a long time as his co-defendants' cases had their preliminary hearings, were dismissed. Eventually, the state dismissed cases against all three other individuals that were charged in that case, along with Mr. Stillwell. Mr. Stillwell was granted bond. And as artists do in their expression in hip hop, it may have been a certain level of fictionalization because we know, in fact, it was not dismissed. He was, in fact, on bond, but that is not in any way an admission of guilt. That is just a statement that I was wrongfully arrested in the past. I paid my lawyer for that. I have no idea how much he paid the lawyer. It wasn't me at the time. But, you know, that's just an expression of artistic freedom. And also, but even if it is based in some facts from his past, it's not an admission to anything. It's completely irrelevant. It's just saying I've been arrested and I beat the case. And it becomes harmful with the next line where he says, me and my slime's above the law. It becomes the idea of bragging, of boasting. That's where the prejudice comes to the jurors. Oh, you think you're above the law because you're rapping about being wrongfully arrested. Now you're free. And now we get to judge you for that. It's very prejudicial. So we have trying to rob them, drug dealers, keeping a stick, and I'm above the law. Okay? No evidentiary value to any substantive charges in this case. Not an admission, it's not intrinsic, it's not 404B, even though we were never given notice of it being 404B. It's just wholly irrelevant to this case, except for maybe I concede the slight relevance, the scant probative value of wearing a YSL chain. I'm not even going to concede wearing red has any probative value to anything, but wearing the YSL chain. And we'll get to the balancing test later on. Regarding the video from where we're saying possibly 2015 in the car, Mr. Stillwell, on that is calling out,
Mr. Chair, before you move on, let me ask you a question.
yes,
You don't believe that your client's statement potentially of I beat a murder rap might be an admission?
it's not in dispute. He was arrested for murder.
Okay.
I mean, that's known. We're going to talk about it. He was wrongfully arrested for murder in October of 2015.
Isn't that one of the predicate acts that the state is alleged in?
I don't see how acknowledging that you were arrested for the murder and either released or
But you
beat it.
sang about it though, and in that for the jury to, I mean, that's directly probably one of the more stronger things that that the courts heard in terms of just,
So if
I mean, involvement, because they can look at it for several reasons, for a couple of reasons. One, he's membership and the fact he's wearing a YSL chain.
Okay,
Two, that he's wearing red, and three, that he's rapping about a potential issue that he's been involved in. So, two, and if it's alleged as part of one of the overt acts, of course, the state's got to lay a foundation as to that, but.
And I'm going to go into 1 and 2, and I'm not going to push back on that, Judge, the chain and if wearing red, but the referencing, if I write a book, if I'm a murderer and I write a book talking about, well, I was arrested for murder and, this was what it was like for me in Rice Street, and this is, and I beat the case, and then the state, and I don't say anything about the allegations. Nothing about guns, nothing about motives, nothing about anything. And then the state charges him with murder 10 years later. I wouldn't see the relevance of me in a book saying, oh, I was arrested for this. We all know he was arrested. He was arrested for murder. He was charged with murder. That's a known fact. I don't know why we need this song to be admitted to show that he was charged.
Was there a trial on the murder?
No, this is the trial.
Okay, all right. So basically, your client's alleged participation in this or commission of this murder is fairly contained with this indictment, correct?
Correct.
Okay, so why wouldn't that be considered potentially a statement against interest or?
Because it's not against interest. He's just stating a fact. He was charged with murder.
Okay.
Against interest.
But you have a choice as to whether or not you want to say anything or. One of the beauties of our Constitution is, hey, you can, a couple things. You certainly have a freedom of speech, but certainly you have, advice of counsel, and certainly you have the issues of whether or not, whether or not you make statements that are against your interests. And especially if you put them in a song, relative to what you potentially might have been involved in, not just, and I'm saying that nexus is something that is a little bit. Baker speaks to, or the court's got to look at in footnote 16. That it's not like he's not involved in the video. He's prominently posted in the video, and it's not like somebody else is attributing those statements to him.
No.
So, I think it's a little different.
Well, I disagree
Sure.
that it's relevant, but I will also talk about the probative value in a second. Okay, to the extent there's probative value, because it needs 403 balancing. I believe it's relevant, but we'll talk about the probative value.
Okay, but remember, in Baker, the person wasn't even in the video, right?
He was.
In Baker?
Yes, he wasn't the artist. I think the gentleman's name was No Cap, was the artist, Mr. Kobe Crawford. The gentleman, Mr. Baker, was in the video dancing with a firearm.
Yeah, but here's the thing about it, but that particular individual neither authored the lyrics or the views or values reflected in the video or adopted or shared by the appellant. So a little different. I think it's a little stronger in this particular video. And that's the jury's determination. This is just a court's threshold issue. But if I'm rapping about, I beat a murder rap, okay? That's pretty, I mean, the jury could consider that as a statement against interest, right?
No.
Okay, well,
It's
we're gonna disagree.
How is being
We're
a
gonna
murder
disagree
rap?
about that.
So if I said,
Well, it wouldn't be wise for one to say I beat a murder rap and the prosecution's
Well,
still open.
whether it was wise or not is a different
Well,
issue. If he contacted me before
You
taped
probably
it,
would have told him, don't say that, right? Or
but
don't
that
write
doesn't
it.
make it relevant.
Well, it's relevant for the jury to determine whether or not he committed a murder.
Saying that you were arrested and let's put context.
Okay, but remember,
If I filed
there's other linkage that has to go on with that. In Baker, it's a little different. The courts are kind of telling us, look, you have to show some particular nexus, and you have to make sure that I mean, and they had beef in this particular case because it was minimally probative. Okay.
What is I'm
In this
failing-
particular circumstance, I think that they've tied, along with the client wearing red, client wearing YSL t-shirt, shirt, and then rapping with other arguably members of YSL about a potential crime that he may or may not involved in. Now, the jury can decide that that's not what it stands for, and they're gonna in weighting the evidence. But under 403 in Baker, the 11th Circuit, as Mr. Steele pointed out in Gamory, 635 F 3rd 480, the rap video in this particular case was minimally probative under 403 because there was no proof that the appellant authored the lyrics or the views and values reflected in the video were in fact adopted or shared by the appellant.
Well, Gamory deals with a different set of facts, but just because my facts don't match Gamory doesn't mean the opposite conclusion.
No, but it tells me, it shows the probative value is stronger in involving your particular accused.
Okay.
And we may disagree with that. I'll have to see what hear what the state says about it, but
fundamentally,
and that's subject also to foundation, but we'll see.
Fundamentally, Your Honor, I just don't probative value. There has to be probative value towards a fact issue.
Yeah, whether or not your client committed a murder.
But he doesn't admit to committing a murder. He talks about being arrested. And that is not an issue. He has been arrested. Nowhere does he say, I committed a murder on that video. If he said that, we'd be in a much different position. And he doesn't say that. And that's the whole point, is all he's saying is I was arrested.
Well, it also depends upon what else the state has to proffer in regards to that. And I don't know what they have. So, I mean.
Okay, well.
So I mean, like I said, so like a lot of these lyrics and songs are subject. That's why under the
regarding
under 103, and I let them in preliminarily, subject to foundation. So, and I'm still going to do that with your client, and anybody else who may be featured in songs or videos. So
regarding staying on the video, okay, and then I'd like to address the other the other video, the social media post as well. But staying on the video, if we were to agree that there's relevance of red YSL necklace and saying he was arrested, that is probative of something, then you have to get to the balancing. And it's prosecutorial need, overall similarity between the acts, and temporal remoteness.
I'm just going to give you a heads up. You got about 10 minutes left, okay?
Okay. Well, so, Your Honor, regarding probative value and prosecutorial need, I'm going to read from Arrington v. State, and that is 355 Georgia Appeals 361 2020.
357.
355 Georgia Appeals 361, and this is
351 Georgia Appeals. Is that what you said? Or 355.
355 Georgia
I'm sorry,
Appeals
thank you.
361.
All right, 361.
And
All
it's 2020 case. And on 364, It says, probative value of evidence derives in large part from the extent to which the evidence tends to make the existence of a fact more or less probable. Generally speaking, the greater the tendency to make the existence of a fact more or less probable, the greater the probative value. And the extent to which evidence tends to make the existence of a fact more or less probable depends significantly on the quality of the evidence and the strength of its logical connection to the fact for which it is offered. Probative value also depends on the marginal worth of the evidence, how much it adds, in other words, to the other proof available to establish the fact for which it is offered. The stronger the other proof, the less marginal value of the evidence in question. And probative value depends as well on the need for the evidence. When the fact for which the evidence is offered is undisputed or not reasonably susceptible to dispute, the less the probative value of the evidence. So
You're talking about 403.
yes, I'm talking about 403.
Remember in Arrington, that was a 404 determination because you have prior bad acts, right?
Right. But
Okay,
that's
so
where that's
are you saying that then I should look at this for the 403 analysis?
403 analysis, because that's
this is giving.
in reality, that's where a lot of our 403 case law comes from, is 404B cases doing the 403 analysis. And the point I'm trying to make, and there's other cases that stand for this same mission, but
It's a little different. You have to agree with, because in determining other acts, you got to look at in probative value. You're looking at evidence offered to prove the intent includes its overall similarity to the charged crime, the prosecutorial need for it, its temporal remoteness. And so when you're talking about that, it's a little different in terms of probativeness. Wouldn't you agree?
well, I'm just focusing on the 403, which is the second prong of the 404B analysis. And so I'm just isolating the 403 analysis. And Your Honor, merely what I'm saying is the state in their discovery has handed over social media posts, hundreds, maybe thousands, several social media posts with Shannon Stillwell on social media, with Slat, with Snakes, with Quindarius Zachary, with other people. If the whole point of this is he's wearing a YSL necklace and he's wearing red, if that's what this is about, A, they could just show a screenshot of wearing a YSL necklace and that would equally prove the point. B, they could show any of these other pieces of evidence shared to discovery. They have a plethora of evidence that they claim ties Mr. Stillwell to YSL and to Quindarius Zachary. So the video, the playing of this video and those rap lyrics, which talk about robbing drug dealers, which talk about carrying a stick, are it's completely unnecessary, and it provides no marginal probative value, because those same arguments can be proven through other means, and that's the whole point of that.
Is robbing the drug dealers and carrying a stick part of the homicide, the alleged homicide?
No.
Okay.
And
Right.
And so danger of unfair prejudice, I think Mr. Steele talked about it, obviously, references to robbery, and I think that's pretty self-explanatory. And essentially what it comes down to, the real value of this is not to show that there's a evidentiary nexus to any of the offenses that Mr. Steele was charging, but the real value is it comes down to propensity, shows a violent disposition. And you know, there's several cases. I know I want to preserve some time. Strong v. State, 309, Georgia 295. Thompson v. State, 303, Georgia 533. Moon v. State, 312, Georgia 31. Arrington v. State, which I already cited. And all these cases come after the change in and again, a lot of 403 analysis comes under 404B in our case law, and it comes after the change in propensity no longer being a permissible use of 404B, and then a 403 analysis to find what non-propensity value does this evidence contain, and then weighing it against the danger of unfair prejudice. So now, Your Honor, regarding the other video, I just want to,
Now, you have to point which one you're talking about.
the
Is that
one in the car,
Stillwell 1 or Stillwell 2?
Stillwell.
Okay, all right.
Okay, so I just wanted to read about unfair prejudice briefly. The term, this is from Baker, and it says, the term unfair prejudice, as it is used in 403, refers to the capacity of some conceitedly relevant evidence to lure the fact finder into declaring guilt on an improper basis rather than on proof specific to the offense charged. And that's citing to Old Chief v. United States, 519 U.S. 172. Generally, such improper bases for a finding of guilt include a criminal defendant's bad character or his propensity for violence. So,
The lyrics in this case are not being offered to show propensity.
well, then redact them. Let's redact them. Then let's redact them. If that's not the point, let's take out references to robbery. Let's take out references to a stick, if it's that simple. But regarding this other video that I want to talk about, Your Honor, in Stillwell 2,
Got 3 minutes.
okay, it's a, if you listen to the video, it's a express, I think it's an express statement to a popular rapper known as The Game. His name is Jason Taylor. I don't know the backstory behind everything, but it includes words such as, this is what got Biggie and Tupac killed. If you come here, I'm at your neck, okay? The Game, Jason Taylor, is nowhere listed in this indictment as a victim or as a witness, okay? There is no, and I'm not, maybe the state isn't planning on trying to introduce this. I don't know. All I know is provided in discovery. It has no direct link to any of the alleged crimes in this case. Again, it portrays Mr. Stillwell as a violent man, as a man who likes to settle his beefs violently, responds to violence. Strong v. State, 309 Georgia 295, prior bad act that shows propensity for controlling other people with violence and responding with violence when people don't submit, was too generic a motive and just bad character. So, and had very limited probative value compared to the great danger of unfair prejudice. Not only unfair prejudice, but a waste of time, and specifically in this case, when we're going to be dealing with the alleged shooting of a bus that another rapper known colloquially as Lil Wayne was on. It presents the possibility of confusion of the issues as well. There is nothing in this case that has anything to do factually with that video that depicts Mr. Stillwell and others. But it does have great danger for unfair prejudice. It will encourage jurors to determine guilt based on those concerns that I read about from the Baker case, that I quoted from the Baker case. And for that reason, that fails the 403 balancing test, the danger of unfair prejudice and other issues, as well as confusion of the issues, substantially outweighs any probative value, which is none in that video. We believe also, going back to the rap video, respectfully, Your Honor, that
Which
the,
one video?
the Stillwell one,
Okay, all right.
that the scant probative value that Your Honor identifies in that video, that I respectfully disagree with, but the scant probative value is substantially outweighed with the danger of unfair prejudice in that video. And so for those reasons, we would ask that Your Honor rule both videos inadmissible in this trial. Thank you.
All right, thank you, sir. All right, who's going to argue for the state?
Mr. Newhouse.
All right.
All right, I got a half hour.
I've already started the timer, sir.
So the broader realization I'm having as I'm hearing these defense arguments, Your Honor, is that this Baker case came out, and it's a case that applies 403, but it doesn't change the law on 403. I think we're getting arguments that sound similar to the idea that, you know, Baker came out and there's this case where a rap video was excluded. So therefore that's now a change in the law that means all rap type evidence is now radioactive under 403. That's a flawed proposition, as I'm going to get into. So I'm going to start with Mr. Williams' arguments, and then I'm going to try to get into Mr. Stillwell's arguments in a little bit more specific. And I may refer to my colleagues when it comes to the granularity, but I just wanted to provide an outline of our thoughts on the law here. So Baker, it's being touted as though it kind of automatically operates to vacate this court's lyrics order from November. That's not the case. It doesn't suggest that. It certainly doesn't compel that. I want to start with the fact that Baker is a 403 case. And as such, it's a limited fact-specific holding. We know that the court and all the parties have read Baker, but just to reiterate, the sole enumeration of error in Baker was the trial court abused 403 in letting this video in, okay? So there was a pretrial motion in limine to exclude specifically this video, by the way, a particularized pretrial motion. And then the trial court's order denying that motion said, oh yeah, it's relevant for identity and it's relevant to show his relationship to this other guy who's unindicted third party, by the way. So with really no explanation, the trial court just said, yeah, it passes 403. And then there you have it, it gets in. Notably, as pointed out by my colleagues, Baker's identity at the nightclub where the incident happened was absolutely uncontested at trial. Further, Baker's relationship with his tour manager, which he had known since childhood, was also totally undisputed, and it wasn't even a material issue in single defendant murder trial. Okay, that's a big difference between the charging posture of that case and the case here. So given all that, it's pretty easy to see how the Supreme Court said, yeah, it doesn't really have any probative value. It's a murder case, and throwing in that video that was filmed, I don't know, several months before, that's got nothing to do with the murder. Highly, wildly distinguishable from the facts in our case. So the video, like there's nothing really in the video connecting the guy to the murder. But meanwhile, what it does show, and what my colleagues had pointed out, was that it does show Baker dancing and brandishing a semi-automatic pistol with apparently an extended magazine, and he's pointing it at the camera, at the jurors when they watch the video, and they watched it 3 times, okay? The prosecution, our colleagues over in Houston County, they made hay with this video, okay? They played it 3 times. They played it once during the lead detective's direct. The suggestion was that, you know, this is a violent gunman. They played it again during cross-examination when Baker took the stand to kind of confront the idea like, oh, well, why would I have guns around? No, this is why. Look at this video. You're a violent gunman. So they're reinforcing this propensity argument in Baker, and then they really nail it to the wall in closing Baker, where they just drive it home that not only is Baker have this propensity to commit gun violence, but he has this propensity to promote it and glorify it in this video. And it became a central focus of the case. I mean, that's right at page 32 in Baker. It was proof essentially of nothing, Your Honor, and it became a central focus of the case in Baker. And so when you talk about, the idea that 403 contemplates that you can look at a piece of evidence and kind of look at its tendency to lure the fact finder into declaring guilt on an improper basis, it's absolutely, I mean, the Supreme Court had to conclude what it did about the video on Baker.
Because of their use of video.
Exactly, because of the fact that it had really nothing, it proved nothing that was at issue. So it had zero probative value, and it had whatever prejudice was inherent in the jury, it multiplied it by 3, and they made absolute hay of it in closing and throughout cross and during direct. And I also want to point out another very important difference. Well, I'll get to that later. I guess I want to just say, look, this case, Baker, it doesn't change 403. It's an example, the court should consider it. And really, the court's lyrics order leaves open at trial objections under 403. So Baker leaves the court's lyrics order undisturbed. That's the headline here. The court's lyrics order is kind of like it's pretty robust. It was pretty assiduously researched, and it accounted for stuff like this. And it left open, as Your Honor is aware, foundation and 403 objections and further findings possibly at trial, if and when such evidence is going to be admitted. So to go ahead and say it undoes the whole lyrics order or any part of it, that is not correct. Everybody has their 403 objections. To say that they automatically exclude any and all states requested evidence under the lyrics order is too much. I want to remind this court that, as everyone knows, 403 is an extraordinary remedy to be used only sparingly, okay? This is not a blanket thing that we're going to use to exclude all categories of evidence that fall under, rap videos, right? And then also I thought, which was interesting, is a Georgia Court of Appeals decision that came out March 14 of this year. It's going to be Anderson v. State, and the Lexus site is going to be 2024 Georgia Appellate Lexus 127, and that's at 8, and it's footnote 3, and it says something that I hadn't actually seen it put this way, but it says the prejudice referred to in Rule 403 addresses prejudice to the integrity of the trial process, not prejudice to a particular party. The reason I want to keep stuff out as prejudicial, but they're arguing that it's not relevant. They wouldn't be arguing to keep it out if it weren't relevant. It is relevant. Under 401 and 402, we're already there. So for that reason, I think the limited nature of Baker as a 403 holding, Your Honor, follow the law to the extent that these, my colleagues' motions are consider Baker. We agree, consider Baker, right? But don't vacate your order and don't alter the order. It stays the same. Now, Baker, as Your Honor is also aware, is highly distinguishable. Again, there was a pretrial particularized motion to exclude a specific video called Ghetto Angels under 403. Whereas to date, at least from Mr. Williams, we have no particularized challenge to any lyrics that were previously admitted by way of this court's order. We have sweeping pronouncements about criminalizing art, generic invocations of 403, 404, but really there's no specific lyric that Woods has pointed to that is attributable to him that he finds objectionable, or at least he hasn't made any argument as to any specific lyrics why they should be excluded under Rule 403. I didn't hear one. I didn't see one in the motion. I didn't hear one argued before Your Honor today. And highly important, Baker, the video had some disturbing imagery, et cetera, but the lyrics were explicitly not at issue. It's not a lyrics decision, Your Honor. It's a 403 decision on imagery. It literally says on page 18, footnote 13, the lyrics have no bearing on our conclusion that the rap music video was improperly admitted. That is highly important. I didn't hear any defense address that, because in this case, the lyrics as statements, by the way, they're not just songs, they're statements, and they're statements by parties in this case. But the lyrics are exactly what was issued, and Your Honor already correctly ruled on the same, okay? We ruled on them as actions of a party opponent on 801 D2A. I mean, John Floyd came down here, Mike Carlson came down here, Deputy District Attorney Hilton, we put on a heck of a proffer. It went for hours, okay? We put them in as adoptive admissions under 801 D2B. They came in under co-conspirator admissions under 801 D2E, statements against interest under 804 B3. And in Baker, they're not talking about 801 at all because the words, the statements, the lyrics were indecipherable. They were not reached. The court made no pronouncement on the prejudicial, if any, effect of lyrics because they just weren't heard. So it's not a lyrics decision. That's extremely important. And admissions, and this goes to Mr. Shart's arguments as well, but when you have party admissions, and we're talking about like a video where we have Stillwell saying the words. You can see him saying these words. I just beat a murder rap. I paid my lawyer $30 for that. Me and my signs above the law. And we're told that that has no relevance to a charged count in this indictment and to overt acts under the RICO count 1 of this indictment. It's a little bit of to me, it's a stretch. But the fact that the Supreme Court in Baker didn't consider the lyrics at all, let alone analyze them under 801, makes this case in a different universe than the lyrics we have here, because it's just not talking about statements. It's not a statements case. And then lastly, a big difference that I noticed in Baker is that it's, again, it's a single defendant murder trial, whereas here we got a multi-defendant RICO and Gang Act prosecution. Williams' motion says, oh, it's no difference that he's charged under RICO and Gang Act. It makes all the difference in the world. All other things being equal, in a single defendant murder trial, it's not necessary or material for the prosecution to show relationships or associations like they tried to in Baker with the guy's tour manager, like that made any difference. And it certainly wasn't required even under the facts of Baker because his association was totally undisputed. So again, the probative value was nothing there. Here, by contrast, and which is consistent with this court's lyrics order, the relationship between and among these co-defendants, as well as their association with the alleged YSL street gang and criminal enterprise, those are crucial. In specific, because the defendants categorically have denied that YSL is either of those things. They've denied that it's a street gang, they've denied that it's a criminal enterprise. So the prosecutorial need to show that is absolutely not minimal or low, as argued by my colleagues. It's extremely crucial in this case in light of those denials. So the lyrics evidence in this case, already properly admitted, relates to, just as a reminder, the nature and existence of the alleged criminal enterprise / gang, the affiliations with the alleged criminal enterprise and gang, participation in the alleged criminal enterprise and gang association and membership, participation, and the connection of the defendants with one another. You can look at your order. It's at page 19, 24, 26, and 37 through 42. Those were already all found to be permissible purposes for the lyrics evidence in this case. So for that reason, Williams' motion should not be granted. And I want to talk about intrinsic evidence, okay? Baker does talk about intrinsic evidence, but that's of no consequence in this matter because in Baker, the only reason the Supreme Court was addressing intrinsic evidence was that the state on appeal came up with this argument, which was not made at trial, that, oh yeah, the video is intrinsic because, and if you look at the oral arguments in Baker, the big argument is Baker thinks he's a shot, get away with murder, stuff like this. That was the intrinsic argument that was made in Baker. So again, it's not hard to see why the Supreme Court rejected that argument. And again, at best, as intrinsic evidence, quote unquote, adding to the story of the crime that happened in one night, a murder that happened in one night, adding to that a video that was filmed several months before and saying that's intrinsic and essential to telling of the story of the crime. Again, the Supreme Court had to conclude that the intrinsic arguments didn't work. And the only reason they addressed them is because the state kind of threw them up as a Hail Mary on appeal. Again, the video provided basically needless corroboration of tangents related to the story of crime. And there was already extensive, definitive, and undisputed evidence at trial of all these tangents. So it's not surprising to see the Supreme Court do what it did here. But again, that rejection, it doesn't affect the state's position in this case or the court's previous ruling on the lyric evidence when it comes to intrinsic evidence. You look at intrinsic evidence on a case-by-case basis. The law on intrinsic evidence is the same today as it was in November of last year when this court entered its order, which appropriately considered the law on intrinsic evidence. And there's a Third Circuit Court of Appeals, a quote that I've found here that I would like to bring to the court's attention, which just has to do with some of the direct evidence. You know, we talked about intrinsic, we talked about admissions, we talked about proving association, membership, et cetera, stuff like that. But then there's also direct evidence, right? And that's nowhere more obvious than when you look at the lyrics that Stillwell is trying to exclude about beating a murder rap and he's above the law and him and his slimes and YSL for life and all this other stuff. It's like, how are you saying that's not direct evidence of what we're trying to prove here? It kind of it seems like it defies logic. But the Third Circuit Court of Appeals in United States v. Johnson, and this is a February 14, 2024 decision, found at 2024 U.S. Appellate Lexus 3436 at page 12. The Court of Appeals in the Third Circuit explained as follows. If someone tells you, quote, I have guns and drugs, and then you find guns and drugs in their house, this statement is direct proof that the guns and drugs are in fact his. That he says it in rhyme does not change that. How a jury chooses to weigh that evidence is another matter, okay? But the evidence is analytically intrinsic. The appellant here, Johnson, contends that rap is often hyperbolic or fictional art form. You know, while not all art is necessarily admissible as autobiography, the district court here acted within its discretion in leaving that question for the jury. And that dovetails, Your Honor, to a little bit of a larger point that I think I'm finding makes sense here, which is a lot of these arguments are very good closing arguments, but to make them now at this stage, it's very insulting to our jurors. I mean, we spent months selecting these jurors, and we screened them for these issues about, are you going to read these lyrics and automatically think they're autobiographical? We took a while the jury, both sides could agree on, say that, oh, they're going to be horrified, they're going to be inflamed, they're not going to know what to do. It's very insulting, especially when you consider the jury, Your Honor, as the constitutionally designated fact finder. And we're talking about arguments from the defense that we got to shield them from all this unsavory detail. They're the fact finder. The Constitution says so. The United States and the Georgia Constitution says so. 403 is a statutory rule, and it's to be applied sparingly. It doesn't override the jury's role as fact finder, in my opinion. The last thing I'll make on this, and I got some feedback here after this, is that, as you're well aware, the lyrics evidence in this case is not propensity evidence. It hasn't been offered as such. And, you know, I think Williams in his motion is kind of just conclusorily asserting that it's propensity. And I guess Mr. Shard is kind of piggybacking on that. There was a lot of discussion in Baker of how it's improper to use propensity evidence, but it's also worth noting that in Baker, the use of the evidence, there really was no arguable reason that they would want to include that disturbing imagery other than to, quote, you know, cast emphatically Baker as a violent gunman. You know, the jury's trying to figure out this murder that happens in one night and the split-second decision that somebody may or may not have made about a bullet that went through a security guard. And then it's like, well, what kind of person would do that, you know? And it's like, well, how about this kind of person? The kind of person in this video. And it changed the whole dynamic of the case. This is in stark contrast to what we have here when it comes to the lyric evidence in this case, which this court has correctly ruled on.
How would you address Mr. Shard's issue of, okay, you got about robbing drug dealers, carrying a stick, and the I beat a murder rap, paid my lawyer 30, etc.
Nature and existence of the organization.
Okay.
So moving forward, I wanted to address something that came up.
I'd argue, well, what about the last statement? Beating a murder rap.
Well, it's a question for the jury. I mean, on one hand, you can say I beat a murder rap, which means I was falsely accused of murder and I was vindicated in court and I had nothing to do with it. And the jury's free to believe that. But then when you couple it with how much you paid your lawyer, you're bragging about money, and then you're bragging above and beyond that, you're not saying me and my clients follow the law. Me and my clients are within the law. You're saying me and my clients are above the law, which goes to the mindset and intent. And so it all goes to count one and then some. So it's not propensity, and the court's already ruled that the lyrics evidence is not going to be offered for that. And if that answers your question, I'll jump forward here a little bit. I wanted to go to Old Chief just briefly.
Okay.
To imply, because there was some discussion about 404B and how that plays into the 403 analysis. Again, Baker was a very limited circumstance where it was no other argument to make other than this had to be used to show propensity to encourage the jury to convict. That's what happened there. But that's not that's not any new type of application of the 403 rule. Again, Baker doesn't change the law on 404B, doesn't change the law on intrinsic, and doesn't change the law on 403 in general. The idea that, 403 encompasses evidence that may lure the fact finder into declaring an improper basis. In Old Chief back in 97, they said such improper bases are to include bad character and propensity. So it's been the law for, some 20 years plus, at least, that propensity analysis does occur within a 403 analysis, and that's nothing new. Again, that goes to my point, which is Baker doesn't change the law on 403. It's been that way before, and it's been that way after. So the court already correctly applied that law in its lyrics order, and for that reason, we want the motion to be denied. And then the very last point I'll make with respect to Williams is that he's apparently trying to resurrect these arguments that failed before about how, oh, because we don't know the provenance of these lyrics or these statements, or the meaning could be arguable, that's some sort of grounds for excluding them. But even in Baker and the footnote that the defense is making hay about, footnote 16, even in footnote 16, it literally says that, or acknowledges that those considerations go to probative value, not admissibility. They're talking about marginal probative utility and how, the failure of the state at trial to show that these people actually said this stuff versus it being kind of, put on them. That goes to weight, but weight is a jury question. The jury resolves the weight, like, oh, they can decide whether they think this means something or other, or whether they think, the fact that Stillwell's up there on the video saying the exact statement, are we supposed to attribute it to him or do we attribute it to someone else for some reason? The jury is fully able and authorized to make those conclusions. So that's going to be my main sort of, one other thing. Baker, the fact that it's so wildly different from this case actually supports the state's position here, if you think about it, because there are so many differences as I outlined. And again, it's an extraordinary remedy that was applied in an extraordinary case. It was called for in Baker. It's not called for here. Just to reiterate, the very fact that the defense's opening statements, their cross-examination, and throughout this case have been categorically to deny that YSL is any kind of criminal enterprise, any kind of criminal street gang, any kind of anything other than a rap label, that elevates the prosecutorial need and the probativity of these pieces of lyrics evidence. And for those reasons, we think that the motion should be denied. Now, when it comes to Mr. Sharp's arguments, those were more recently filed, so I don't have as developed of a take on them. I may refer to co-counsel for some of these details. But the Smile Off video, let's call it, what was that, Stillwell 1?
Yes.
I think we kind of already covered that with the pay my lawyer 30 to beat the murder rap, me and my slides above the law. I mean, that's him talking. Like, there's no question about him being the person that said that. And more than that, you look at
being offered for any other reason other than identity, and are you talking about identity for what reason?
Well,
For involvement in the criminal street gang, or identity in terms of the homicide?
well, it could be for all those, but
I'm asking you because Mr. Shard has said, "Oh, it's not really relevant," but he won't kind of concede that. But so tell us, or tell the court why it is it, or address those three issues. One of them is he's robbing drug dealers. Okay, I mean, and he carries a stick. The last thing is I beat a murder rap for 30. I beat a murder rap, paid my lawyer 30, and then me and my slimes are above the law.
Well, I mean, that's overt Act 95. And so if you look at the indictment, overt Act 95 literally says that statement is in furtherance of the conspiracy. If we can't play a video of him saying those words, how else can the state prove that act?
What about robbing drug dealers and carrying a stick? Should I exclude that?
No.
Why not?
Well, it provides evidence of the nation existence of the organization. It's not.
That's why I asked Mr. Sharp. Did the homicide occur as a result of robbing a drug dealer, or was it allegedly Mr. Stillwell carrying a stick, assault weapon?
Well, there had to be some sort of weapon for this murder to have occurred. I don't have any specific nexus about why the sort of words before the words that are admissible are specific to this, but we do have an entire overt act built around it, and the things that are said in context right before, right after, sort of YSL association, even in the Civil 2 where you have YSL for life and you have blood love all the time. You have all these indicators of this is evidence of the organization.
I get all that, but the specifics of robbing drug dealers and this defendant's reportedly carrying a stick, what relevant? I mean, that could potentially, though. I want to parse out those three statements. I don't have any. Unlike Mr. Shart, the court doesn't have any. I disagree with him about the murder, about the statement about the murder rap. Okay, but I do think that you're going to need to address the issue of the robbing drug dealers and carrying a stick. unless you're going to, you know, like I said, lay more foundation in regards to that.
Well, you're gonna have, we have allegations that Dirty Red is a drug dealer. We have Donovan Thomas, who was murdered with an assault rifle. And there's indications that it's a rival gang situation. So it's not maybe
The issue with Donovan Thomas hasn't come up yet. At least I don't think so. The evidence hasn't been presented, but Dirty Red was just covered just a little while ago. So flesh that out for me in terms of robbing drug dealers or Dirty Red.
Well, they're talking about the stuff they do. I mean, talking about the way they do it. It's a party admission, Your Honor. These are parties making statements about the things that they do. It's highly probative. I mean, this is not somebody else saying something and it gets slapped on here. And there's, you know, and they're not like in that Gamry case where you have a video where the defendant wasn't even present in the video. You have them. These are party admissions. Like what a defendant says, unless there's some specific statutory rule excluding it, you know, like Miranda or something like that. These are extremely probative statements. And to just say, oh, the jury's going to be inflamed, we have to shield them from these facts, these things, these statements, these words that the defendants uttered for really, I don't know, no reason at all. To me, it just kind of strains credulity. And
I'm just making sure that, you know, under, you know, Gamory, that Gamory, that, you know, you got a video there that was minimally probative. I'm just asking you, as a proponent offering this particular evidence, if it's going to go to more, if what you're going to present will potentially be more probative than it has to be more probative than prejudicial, not minimally probative.
That's correct.
Okay.
And I take the court's point, which is that some of that stuff in Stillwell 1 is maybe more, at this point, obviously probative and direct than some of the other stuff, which maybe at this point apparently more diffuse. But again, we have.
That's why I'm telling you at this point in time. I mean, all of it's subject to foundation, but you know, certainly it's something that I'm watching. I'm watching for the other stuff I've already admitted, but you know, or at least conditionally. And I think Mr. Shard is just raising this as part of his issue under what's been presented so far and under Baker.
Sure. And then I guess I'll just leave with one other piece of grain of sand here, which is the witness that we're kind of in the middle of, Miss AB. State's theory is, of course, that, you know, she was robbed, she was dealing drugs, you know. I mean, I can think of a lot of different things that the lyrics could apply to. There's no, with regard to those particular lyrics, I'm not able to pin down exactly one part of the case that applies to, but to say,
well, that's what you have to. I mean, that's kind of what Baker and the other cases kind of tell me, is that I just can't admit this for shucks and giggles. I'm being over dramatic, but you have to admit it for tying to some specific or linkage from some particular nexus.
well,
So that's why I'm telling you that, you know, that's why it's important.
I'll just default, Your Honor, back without wasting any more time. I'll default to the idea that it's an admission of a party concerning the nature of the enterprise.
Okay.
And how things work.
All right.
And with that, I guess, unless there are other questions, I'll conclude the presentation.
No, I'm good. All right. Thank you, sir.
Yes, sir.
All right, folks. I'm going to take probably about 10, 15 minutes. I need you to take comfort, and I would encourage y'all to do the same. And then I'll come back and let you know my thoughts, okay? All right, so we'll be in recess for about 15 minutes.
in the context of what happened.
Wes. And I understand your clients have had the opportunity to have lunch, so that's what we also delayed for a little bit. All right. The court's had an opportunity to consider Mr. Williams' supplement to motion limiting number 2, motion to strike filed on 3/6 of 2024, which also includes a copy of recently decided cases the court mentioned earlier by our Supreme Court of Georgia, Baker versus the state, decided March the 5th of 2024, S23 Alpha 0860. Related to that particular case as well, the court has also considering Shannon Stillwell's motions, 1, to exclude irrelevant and prejudicial audio and video evidence, and then supplementing that, or in addition, motion limiting or motion to strike regarding song lyrics. To that extent, the court has admitted for the purpose of the motion Stillwell's 1 and 2, which are videos that he wished the court to consider excluding for those particular propositions, both in the motion to exclude and then which was filed on Stillwell 3/25/24, and then motion limiting motion to strike filed on 4/1 of 2024. The court will also admit for purposes of this particular hearing and for purposes of the record, and take judicial notice of the court's order entered on May the 27th of 2023, order granting the state's motions in limine to admit evidence of lyrics at trial and deny defense motions to exclude lyric evidence at trial. I will include it as the next court exhibit in order for purposes of this particular motion, a 43-page order. Chris, I've already sent you a copy of that. All right. So, and also, the courts considered the state's response to defendant Jeffrey Williams' March the 6th of 2024 supplement to motion limiting number 2 and motion to strike. After giving careful thought and consideration to the aforementioned motions, the court rules as follows. It is the court's opinion that the defense's reliance on Baker is in fact is also limiting and is fact specific, and in regards to the facts of this case at hand. In Baker, the enumeration of error was the trial court abused its discretion of 403. In particular, the court failed to do a 403 analysis. And much differently than this court's analysis, this court did a fairly exhaustive analysis as is contained in its order of 11/27/2023. Given the facts that are distinguishable and the court, since the court in fact did an exhaustive 403 analysis and also the independence of basis of its admissibility, I believe that the court is still of the opinion that Baker, although good law, does not apply at this point in time to the facts and circumstances of the matters involving Mr. Williams as well as Mr. Stillwell. The court's also considered in this distinguishing of Baker. In Baker, the Georgia Supreme Court explicitly stated the lyrics have no bearing in our current conclusion that the rap music video is improperly admitted. In this case, the court is primarily subject to foundation and the state's proffer that these particular statements are admissions of a party opponent under OCGA 24-8-802 Delta 2 Alpha, adoptive admissions under OCGA 24-8-801 D 2 Bravo, co-conspirator statements under OCGA 24-8-801 Delta 2 Echo, and statements against interest under OCGA 24-8-804 Bravo 3. And also distinguishing in this case, Baker was a single defendant murder trial. This is a multi-defendant RICO and gang prosecution. So there are differences in the factual predicate as alleged and as applied in Baker. In respect to the in fact, the propensity argument argued by in particular Mr. Stillwell, Baker specifically, the video in Baker, other than connecting Mr. Baker, connecting Mr. Baker and casting him as a violent gunman, and also then the little next to I should say the nexus that was much weaker than in this particular case at hand, and is in contract to the lyrics as in this case, which the court has preliminarily found to constitute direct evidence of the crimes charged, subject to a foundation that must be laid, and in this particular case, and I am of the agreement that the provenance or meaning of the lyrics is a matter of weight, not admissibility. But that is after the court has done a fairly exhaustive 403 analysis in my earlier order filed on the 27th of November of 2023. So for the above reasons, one more thing. For the above reasons the court cited, I'm going to deny Mr. Williams' motion to limit, supplemental motion limiting in regards to number 2, as well as Mr. Shart's, on behalf of Mr. Stillwell's motion to exclude irrelevant and prejudicial audio and video, as well as the motion limited to strike regarding the strong lyrics. I will authorize the state to, consistent with my earlier rulings, subject to a foundation, to attempt to lay this with sufficient foundation as it relates to that. Relates to the admissibility of Stillwell's 1 and 2, as well as the evidence that the court, in terms of lyrics and songs, has admitted thus far, consistent with its order on November the 27th of 2023. All right, so that's that. Folks, what I'd like to do is, since we have not taken lunch, is to maybe for us to take about 40 minutes and come back about 1:35 or thereabouts. And then I'll take up Mr. Weinstein, Mr. Kendrick's motion to limit the witnesses and the amended motion to admit or to limit the witnesses, okay? All right, so I'll see everybody back at 1:35. All right, we're in recess. All right. As a matter of housekeeping, councils as well, I am in possession of Mr. Williams' motion to enforce disqualification that was made orally last week by Mr. Steele, filed on yesterday evening. Ms. Love, if you could file, you and your team or the state file a response no later than by 5 o'clock on the 3rd, and that motion alone that morning, and that would be the conclusion of our business.